Now, what is the meaning of rule of law? We have heard this word many times. Rule of law, general meaning is that it is the law that rules. It is not the king, it is not the religion, it is not the tradition, it is not the morality, it is not the prime minister, it is not the president, it is not the chief minister, it is not the director, it is not the vice chancellor who rules. It is the law that rules. If we go back in ancient days, one verse we can find Yatu Dharmastatu Jaya. This is provided in the emblem of the Supreme Court. जहाँ धर्म है वहीं जय है. Dharma does not mean religion here. Dharma has a very wide meaning. Dharma indicates duty, indeed the higher duty. Dharma indicates something close to what law means. जहाँ लॉ है, जहाँ धर्म है, जहाँ कर्तव्य है, वहीं जय है. There are many scriptures which suggest that even Vishnu is under dharma. That indicates that even Vishnu is not above dharma. He has to follow some dharma. That means he has to follow some law. In the current days, we say we all have to follow law. We all are under law. That is known as supremacy of law. In England, there was a rule: the king can do no wrong. Why? Because king represents God. King represents church. And therefore, as God cannot commit any wrong, therefore, king cannot do any wrong. It was a blind obedience to those in power. Indian concept was different. Indian concept never said that king is can do no wrong. It suggested king can also do any wrong. Indeed, the God can commit wrongs, but everyone is under dharma. So Indian wisdom was far more conscious, far more advanced in comparison to Western philosophy. Unfortunately, we lost that wisdom. We are not very much conscious to our Indian wisdom. So the idea in Britain was that whatever king says, that is final. You cannot question him. And therefore, any decision, he could take any decision. And what happened? Ultimately, that there was arbitrariness, there was nepotism, there was persecution, there were atrocities. I have moved the slide. A concrete concept goes back to Aristotle, who says that law should govern, not the person. There is an old case of Dr. Bonham, where in a case, Chief Justice Edward Coke has declined the request of James I, who was the king. He was such a courageous person, courageous judge, Edward Coke. In 1552 to 1634, he stayed, and in the 17th century, beginning of the 17th century, when James I, the king, directed that certain decision has to be made in this fashion, Edward Coke has declined to honor and said it is not you that rule, it is supremacy of common law. Such was the courage, and even after 600 years, we are discussing him in India. Thousands of, and he is being discussed, Edward Coke is being discussed all over the world. There may be many judges we do not know, but only those who are courageous, who value law, spirit of law more than his own position, They are those who are remembered in the history. Otherwise, rest of them go in the dustbin of history. Ultimately, in 616, he was removed by the Chief Justice, Lord Chief Justice. But then he became a part of history. Even after 600 years, we are discussing, and maybe next 300, 400 years, we are going to discuss him. Far more concrete concept of rule of law can be found by one of the great British author, A.B. Dicey. He provided this concept of rule of law in a concrete sense. And his idea contains 3 points. One is authority of law. So rule of law means authority of law means everything should be under the authority of law. Everyone is under. So if I want to do something, or you want to do something, or king wants to do something, or the prime minister wants to do something, he has to find an authority of law. That law must have permitted it, or at least law must have allowed it indirectly or directly for the purpose of individual. But please take note, we will discuss later on. Rule of law has 2 different meanings for a citizen and as well as those in power. But one thing is there, that authority of law is important. So if you want to punish a person, there must be a punishment in advance. There must be a law in advance. So today we know that suppose I am moving and I find there is a hungry man, and he says that I am hungry maybe for last 3-4 days and I will die, and I have money or I have some food, but I don't give him, either because I think he is begging and begging is crime, or because of any other reason, or because I don't care, and the person dies. Did I commit a crime? No. Not feeding a hungry person is not a crime. I may have committed some moral wrong, some social wrong, but it's not a crime. So one cannot be punished unless something is declared by authority of law as a crime. So the first important thing is we must look for that where is the law for it. I want to do something, is there any law for it? So that is authority of law. That a person can be, a law can initiate against a person if it is declared in advance. Under Article 20, Clause 1 of the Constitution, it is provided ex post facto law, that a person cannot be prosecuted or punished unless there is a law which makes it crime in advance. So first is the authority of law. Just because I am in power does not mean I have the authority of law. Just because my intentions are good does not mean I have authority of law. Authority of law means it must be mentioned somewhere in under law. Everything I understand is cannot be mentioned under law, so we not to be so technical, but substantial, some power that we are exercising against a person must be under certain law. Second point is supremacy of law. Supremacy of law means everyone is under law. Prime Minister is under law, Chief Minister is under law, DM is under PM, CM, DM. All is under law. And it is the law that rules, that is known as supremacy of law. So whether it is Anurag or it is Ambani, all are under law. Even judges are under law. The parliament is under law. The executives are under law. That is supremacy of law. And third is spirit of law. A.B. Dicey says. Spirit of laws means the rights of a person should be taken note of. And the law should not be made in such a fashion which goes against, which does not consider the substantial rights of a person. So rights of a person should be taken care of when you make law, when you apply law. That does not mean the rights cannot be infringed. Rights can be infringed, but that is subject to the constitution. That must be provided somewhere. Restrictions are provided in our constitution itself. So therefore, friends, rule of law has three meanings. One is authority of law, second is supremacy of law, and third is spirit of law. So prior to Dicey, there was a thinking that you cannot question the king. You cannot question why law is made, how law is made, where is the law. If church says that okay, this is the law, then it is final. Nobody can question because they are representative of God. So there was a divine right, I think. But A.B. Dicey had challenged it and provided a far more concrete version of rule of law. That is also true for international law. That under international law, there must be some authority of law. We cannot just keep on speaking that this law is there, this law is there, this law is there. If a specific action has to be taken under international law, something must be shown, even if the intentions are good. Now, what is the relevance of these type of topics that we discuss investigation abroad? The relevance is that we must be aware of what is happening under domestic jurisdiction as well as international jurisdiction. The more we are aware, the more we are empowered. One can see the impact of international law on domestic law. For example, you take care of JJ Act 1986, now it is 2015 Act. It was made under Beijing rules. We have Protection of Human Rights Act of 1993. It came after Vienna Convention. We may take example of UAP, Unlawful Activities Prevention Act 1967. It was amended in 2004. And in the objective clause, there is some recognition of international law that you can see in the slide. I am moving fast because time is not permitting me to move more. You stay. But there is a recognition under international law. Our domestic law is being influenced by international law, and therefore we must know what international law is. Why this international law has become more important is because the judiciary has also started recognizing it. For example, take the case of D.K. Basu. D.K. Basu case was decided in 1997, which held what are the rights of an arrested person. They all discuss these things with the help of international law. When we are not aware of international law, sometimes our very serious activities go in vain. There is an example of gun runner Niels Holm or maybe Raymond Verle. Many extradition cases fail because we are not very well aware of extradition laws of other countries. Therefore, if we are aware of international law, then it will certainly help us in preventing and prosecuting the offenders. I have skipped some of the part because I want to come to the core area. So what are the rule of law? What does it mean in the context of international law? Very simple. One can note it down. Rule of law is set of values and principles associated with the idea of legality. This description is given by United Nations for all countries. Rule of law is not just law in black and white. Rule of law is set of values, set of principles. ऐसे मूल्य है, ऐसे सिद्धांत है, उनका ग्रुप है, ये उनका सेट है मूल्यों का और सिद्धांतों का, एसोसिएटेड विद द आइडिया ऑफ लीगलिटी, जो किसी कार्य की वैधता से जुड़े हुए हैं, जो वैधता की धारणा से जुड़े हुए हैं. कोई चीज वैध है या अवैध है, इसके संबंध में लॉ तो बताता ही है, पर ज्यादा इंपॉर्टेंट क्या है? ज्यादा इंपॉर्टेंट है वैल्यूज और प्रिंसिपल्स जो उसमें है. So it is set of values and principles. It is not rule of law means something is written in black and white in certain laws. That is one meaning, a small meaning. That is a one technical meaning. And therefore the description goes on. Law means law are three P's: principles, policy, provisions, precedents. I would say four P's. Law are four P's: principles of law. What are principles of law? Presumption of innocence is a principle of law. It is not written anywhere. You can hardly find this principle, such an important principle of criminal law. This presumption of innocence is the beginning of any trial in the court of law. A prosecution has to neutralize this idea of presumption of innocence completely. So these principles of law. There are other principles also. For example, there are principles that prosecution has to prove his case beyond reasonable doubt, but accused is not required to prove beyond reasonable doubt. Mere preponderance of probability will be sufficient. They are the principles of law. Policy of law. Policy of law. Policy keeps on changing. Principles are rather far more permanent. Provisions of law. Provisions of law. Law in IPC, Law in Prevention of Corruption Act, law in UAPA. They are provisions of law. And fourth is the precedents of law. Precedents of law means generally judicial precedents. What the judiciary has decided, how the judiciary has interpreted, and they are the law of the land. Sometimes it is not mentioned in the law. Let me give you a small example of Lalita Kumari case. Lalita Kumari case, Lalita Kumari versus Government of UP. The issue before the court was whether FIR registration is mandatory or not. Because when a person complains to police, he might be giving false information. So should the police register a false information? The Supreme Court said yes, you don't go in false information or right information. Once there is a disclosure of cognizable offense, you are bound to register an FIR. It may be false, it may be correct, that is a matter of investigation. But at the same time, so why this thing is written already, that an FIR shall be registered. But what is not written in the text is that there may be preliminary inquiry in 5 exceptional cases. So cases against doctors regarding their profession, domestic violence cases, commercial litigation, commercial fraud cases, commercial cases, and corruption cases also. These are the exceptions where FIR shall not be registered immediately, but a preliminary inquiry can be taken. So that means these are the precedents. These are not written in CRPC. Of course, Prevention of Corruption Act 2018 and prior to that, other provisions had made similar type of provision. So that way law means they are principles, policy, provisions and precedents. Then there are two targets of rule of law. One is institution, other is individual. Rule of law is not required to be followed by institutions only, like parliament, like executive, like judiciary, like Indian Law Institute, like CBI Academy, like CRPF Academy. No, institutions are certainly made to follow rule of law, but individual is also required to follow rule of law. Rule of law does not make any exception to individual. So as an individual, I have to follow rule of law, and so are my family members, and so are everyone, every citizen in our country. He is bound by rule of law. So rule of law is not just for state, it is for individual also. So at this level, there is same idea that everyone is obliged by rule of law. Everyone has to follow rule of law. I've changed the slide. I have discussed this institution. NGOs are also part of the institution. They are also required to follow rule of law. Now, individual have a duty, but then there is a difference. I will come to this difference. When we say that institution and individual, they are similar when we follow rule of law. But then there is a very important difference, very significant difference. And what is that significant difference? I made it full screen, I think it is visible. That let us know who is an institution. So when I represent ILI, ILI is an institution, I am representative of ILI. My students are there, of course they are students of ILI, but they are also there in the individual capacity. Because I am in power, I have authority. Similarly, those in authority have a different type of responsibility. So institution is required to work under authority of law. If they want to do something, they must seek an authority. Where is the law for it? But in case of individual, this is not so. Of course, they are also under rule of law. They cannot do something which is against law. But at the same time, suppose there is an area where there is a vacuum. No law is mentioned. What does it mean? It has different meaning if it is individual, and it has different meaning when it is institution. For an area, suppose there is an area where there is no law, then individual is permitted to do. Vacuum of law can be used by individual in his favor. Gray area of law has to be used in the favor of individual. Benefit of doubt has to be given to the individual. But same is not the case of institution. There is a gray area, and an institution may be Cbi Academy, maybe a college, maybe a university, maybe parliament, maybe an executive indeed. Not parliament, but executive, is trying to use gray area, then the gray area cannot be used in the favor of individual, in the institution. It has to be used in favor of individual only. So for certain purpose, there is no law, there is no authority. That means the institution cannot do it, and the individual get the benefit of it. So for a gray area, for a vacuum area, individual can take the benefit of not having a law. Institution cannot take the benefit of that. So that we need to understand as a matter of difference between rule of law for the purpose of institution and for the purpose of individual. This is the definition of rule of law for a nation. I have already discussed with you. I have changed the slide. I am trying to analyze this slide again, rule of law, because I have already done, but just for clarity, additional clarity, I am doing it. Rule of law is a principle of governance. It is not something written. Please take note. Something which is written in book, in rule book, is not rule of law. That is rule only, but not rule of law. But it must have certain values, must contain certain values. What are the values? Values written in our preamble. Preamble is the beginning of the Constitution, which talks about justice, talks about equality, talks about liberty, talks about freedom, talks about rights. So, rule of law does mean not only something written on rule book or textbook, but it must be informed with equality, liberty, fraternity. If it is not there, then rule of law does not exist. There is some lack in rule of law. Second important point is rule of law is for all the persons. I have already discussed with you. No exceptions. And that's why we see that even if you are a very, very powerful person, very, very strong person, rule of law is for you. So we have found former chief minister going to jail. There are many examples that the chief ministers have gone to jail. Ministers, even home ministers have gone to jail, former home ministers. Many billionaires have gone to jail. Take example of real estate owners. They thought that we have thousands of crore rupees, so we can do anything. We can buy any lawyer, we can buy any judge, but that was not possible under rule of law. We must have many shortcomings, there is no doubt. Every day rule of law is violated, that is also correct. But then conceptually speaking, we have a rule of law. It may not be followed at every place, but that is not the fault of rule of law, that is the fault of application of rule of law. It is applicable to all the persons. It is applicable to institutions and entities, be it private or state. I have already discussed. So everyone is accountable to law. That is the meaning of rule of law. When we say that someone is accountable to law, it has certain preconditions. What are those preconditions? The law must be publicly promulgated. I have made a law, I am a boss, I have made a law and I have kept it inside my drawer and I will use it when required. No, it must be publicly promulgated. People should know what the law is. It must be placed in a conspicuous place. So that's why Parliament makes a law, and executive makes law, or judiciary make law. They are open to anyone. They are available on websites. One can see it. In Anuradha Bhasin case, 2020, Jammu Kashmir internet shutdown case, certain executive orders were issued under section 144 of CRPC. but they were not publicly available. The Supreme Court said that no, you have to make it publicly available. Something which is confidential, that is understandable. Something that deals with national security, that is also understandable. So that way, there are limited things which may not be made publicly available. But a law can be made, law has to be made publicly available. Second is that it has to be equally enforced. It cannot be enforced for one person and cannot remain unenforced for other person. Third is it has to be independently adjudicated. In case of disputes, there should be some machinery which is independent of executive and government, and we have a Supreme Court. No interference by parliament, no interference by executive. And therefore, our Supreme Court can be said to be one of the most independent Supreme Court in the world. That sometimes also becomes a type of burden for country. In USA, political persons are appointed, persons having judges, persons having great judicial acumen, but political affiliation are appointed. That is not our case in India. So it should be independently adjudicated. Independently adjudicated under rule of law, not just People's Court of Maoist Communist Party, or not just a Khap Panchayat having no legal backings. So I'm skipping these parts because of lack of time. I've already discussed these things. Rule of law for the purpose of individual and for the purpose of government. Just to refresh again, that if there are grey areas, individual get benefit, not the government. Government must do something with authority. If there is a grey area, government cannot say, I have interpreted it, I have interpreted in my favor. If there is a conflict between individual and the state, it is the individual that gets benefit. So any loopholes in regulation or law, it goes for the benefit of the individual, not for the benefit of state. So state must look for some law. I can just cite 1-2 example that how the laws and the principles differ from jurisdiction to jurisdiction. One case is Vyasram versus State of Bihar, 2013. The issue was that suppose there are 4 witnesses in a case, in a murder case. 3 witnesses have given contradictory statements, doubtful statements about an incident. But the statement of one witness is beyond doubt. So out of 4 witnesses, 3 witnesses have given doubtful statement, but one witness has given a statement which is beyond reasonable doubt. What should the court do? Because there are 4 evidences presented by the state, 3 are vague, doubtful, 4th is only good. Should we decide on the basis of quantum? That 3 is bad and 4th, 1 is good, so therefore the benefit should go to individual? No. Why? Because in our case, a different principle is applicable. What is the principle? Falsus in uno, falsus in omnibus. False in one thing, false is everything. It is a principle which is applicable in various jurisdictions. That if there are 4 evidences and 2 are not good evidences, then all the good evidences have to discard. That is not the principle that we use in India. But the principle is used in Britain. So in Britain, you have to present a far more stronger evidence than in India. So if you want to convict a person, want to get some maybe prima facie case for the purpose of extradition, in India, one can present that, okay, there are 4 out of 4 evidences, there are 3 evidences which are bad, but 1 evidence is good. You can get an order in your favor. But in Britain, it is not possible to get it because the principle applicable is different. If your one evidence is bad, then the whole evidence is supposed to be bad. Similar is the case for dying declaration. We should know the difference between dying declaration under various jurisdictions. We also should know that what the laws on arrest in India and maybe in other countries. So fortunately, there is not much difference in both the countries, but we should be aware of International Covenant on Civil and Political Rights under Article 19.1 makes it clear that everyone has a right to liberty and security of person. No one shall be subjected to arbitrary arrest or detention. No one shall be deprived of his liberty except on such grounds and in accordance with such provisions as are established by law. Similar is the procedure in our country under Article 22 of the Constitution. It is mentioned that when a person is arrested, he should be given a ground of arrest, and then he is at liberty to contact his lawyer, and he can be defended by a lawyer. These things are not available to a person under detention, but these are available to all the persons, even if foreigner. I am citing a small case, Kilik versus Turkey. Where the court held that it is the primary duty on the state to secure the right to life of a person. But at the same time, it says that there is a Lakshman Rekha. There is a line which is decided, which is divided. And the line is that we should respect human dignity. So, respect for law or respect for rule of law, the application of rule of law contains both things. That we have to harmonize between application of law and the rights of individual. Rights of individual which are available in the Constitution. We may sometimes disagree, but then we have to follow it. Now, in context of Universal Declaration of International Law, we have various international documents which mandates what rule of law is. And the earliest one is Universal Declaration of Human Rights, 1948. It is a declaration, it is not binding, but then this declaration is one of the most important declarations. We have to give utmost respect to it, despite it is not binding. However, other documents like International Covenant on Civil and Political Rights, 1966, they are binding on us and binding on many countries. All those who have signed, and most of them have signed and ratified So if we have signed it and we have ratified it, then we are bound by it. We have to follow it. But there can be a possibility that there is a law, there is an international convention, covenant or declaration that we have not signed it, or if we signed it, we have not ratified it. Take example of Convention Against Torture. Take example of Convention relating to status of refugees. Of course, they are also human rights document, but they are not applicable for purpose of India because we have not ratified it or we have not signed it because of our own reasons. But if it is ratified, if it is signed, then we are obliged to do it. So while civil people, NGOs can argue on human rights ground, we may successfully argue on the ground of international law that unless ratified, we are not bound by these laws. So we should see if something is we are going to do in abroad, are we obliged to do it, or it is just a matter of courtesy. Of course, if it is a matter of courtesy, then we should try to do it. Just because it is not bound does not mean we should not obey it. Everything cannot be written, because as earlier said, rule of law is not something which is written law. It is a set of principles and values. As far as possible, we have to apply those against which there is an obligation, we have no option. But even if there are others having no obligation, we should try to do it subject to the conditions that is available for India. Maybe national security, maybe our own special circumstances. There are regional treaties also that talk about various human rights, and therefore they also form rule of law under international law context. I already discussed with you status of a refugee convention. India has not signed it. There is great pressure these days that India should do it, but India is not doing it due to various reasons. One reason is that we have very hostile border, either from China or from Pakistan. Myanmar and Bangladesh is also there. So, in the form of refugee, maybe it can be a threat to national security. So there is a reasonable apprehension, and therefore, right from Pandit Nehru to Narendra Modi, we have not signed it. There are some reports also why we have not signed it, but I am skipping this part also. This I think is far more significant and relevant for our purpose, especially for the purpose of those who are attending today. Now there is a case Abu Salem versus CBI 2011 case. The court observed that the analysis and reasoning rendered in the impugned judgment with regard to the interpretation of principle of speciality, and we will discuss in the next slide what is principle of speciality, it still stands good as the law declared by this court under Article 141 of the Constitution of India, shall be binding on all courts. So principle of speciality is applicable if we go for extradition of someone. What is that principle of speciality? They are saying Lahoria versus Union of India that says what is principle of speciality, which is applicable for the purpose of extradition, and therefore those engaged in this should be conscious of this. What is that? I think the slide is visible to all learned persons. If it is not visible, please let me know. Principle of speciality is the doctrine of speciality is yet another established rule of international law relating to extradition. I discussed with you that rule. We are discussing rule of law in context of international law. Doctrine of speciality is a principle, may not be available in black and white sometime. So presumption of innocence is not maybe written everywhere, but they are also principle of international law. So doctrine of speciality is yet another established rule of international law relating to extradition. Thus, when a person is extradited for a particular crime, he can be tried for only that crime. If the requesting state deems it desirable to try the extradited fugitive for some other crime committed before his extradition, the fugitive has to be brought to the status quo ante, in the sense that he has to be returned first to the state which granted the extradition, and a fresh extradition has to be requested for the latter crime. The Indian Extradition Act makes a specific provision to that effect. So if extradition is requested under certain provision, maybe 302 of IPC, and we want to prosecute him for maybe some other law, and there is no mention in the extradition document, then the rule of law on the international law principle of speciality bars us to do it. And if as an institution we do not follow it, we lose extradition. Daya Singh Lahoria 2001 case further suggests, in view of Section 21 of Indian Extradition Act 1962, an extradited fugitive cannot be tried in India for any offence other than the one for which he has been extradited, unless he has been resorted to or has had an opportunity to return to the state which surrendered him. The doctrine of speciality is in fact a corollary to the principle of double criminality. Double criminality or double jeopardy. It is also a part of our constitution. Double criminality. And the aforesaid doctrine is premised on the assumption that whenever a state uses its formal process to surrender a person to another state for a specific charge, the requesting state shall carry out its intended purpose of prosecuting or punishing the offender for the offence charged in its request for extradition and none other. So principle of speciality is one of the very, very important principle of international law. I had discussed with you under Section 20, under Article 20 of the Constitution of India, no person shall be prosecuted or punished for the same offence more than once. Strictly, this does not apply in these cases, but this has some link with principle of speciality. Now, another rule of international law can be found under International Criminal Court, Rome Statute of International Criminal Court, 2002. So, where the state representatives can be prosecuted for war crimes, for crime against humanity, for crime against aggression, for crime against peace. And then statute of 2002, Rome Statute of 2002 of ICC is a very, very important document, and those who are dealing with criminal law, they can see that, because many principles which are not written in our jurisdiction are written in ICC also. That is International Criminal Court Statute. It is mentioned there. That will, like, indeed the definition of intention and knowledge is provided. How to interpret the law, that is provided under ICC. So that is an important document for the purpose of international law. International offenders, they are offenders who have pan beyond India influence. They have connections. They can launder money from one place to other place. White collar criminals. For these purposes, there is a special convention and covenant made, that is Covenant on Transnational Crimes. If time permits, we shall try to do that also.